Good afternoon, Mr. Matshitse. I'm sorry. How do you pronounce your name? Matshitse.
Matshitse, like Dore.
Oh, thank you.
Thank you. Good afternoon, Justice Maya.
Are you well?
I'm fine, Justice Maya.
All right. You have a diploma, a deep juris.
Yes, Justice Maya.
Mm-hmm. I didn't know. When was I didn't know you could jump straight from deep juris to LLB.
I beg your pardon?
I'm saying I did not know that you could do an LLB with a deep juris and not a B juris.
Okay. During the time at UNIBO, or as we call it UNIBO in Northwest, yes, the difference was that it was a question of one did not have what we call an exemption, and you were allowed to do the courses like any B juris student. Then in between, you'll get that like on the CV, I did attach it from UNI's exemption due to age and improving yourself in that regard. And thereafter, you were allowed and permitted to do LLB straight from there.
Oh, I understand now. So you did that diploma, then you did the LLB, and then an LLM in commercial law.
That's correct.
But you were not satisfied. You registered for yet another LLM in insurance.
Yes, I think I'm on the last course of LLM UNISA. I'm left with mini dissertation.
Yes, yes. But you have other qualifications as well. You have some certificates, and you just don't stop learning.
I like reading. That's the problem.
But commercial law is your area, your one area of interest.
That interests me.
That's
Justice
good.
Maya.
All right. You've been around. It took me a good minute to figure out precisely what you did, when, and how to tie in everything.
Yes.
But I see that between 1994 and 2015, you practiced as with 7 firms of attorneys.
Yes.
As an
the late
attorney.
Monama.
Why did you hop around so much?
I beg your pardon?
Why did you hop around so much? What was going on there?
Sometimes they say when you hop around is that you are not afraid of a challenge. You are going around to expand yourself, have a knowledge, and sometimes that firm of attorneys wherein you join, it's got something that you need that you expand your interest in. For example, but when I left Mabatu in 1996, after the new dispensation coming to Johannesburg, the aim was one, to come and expand and understand the law, because I was the first black notary and black conveyancer, and we had a problem of getting conveyancing work. As you know, it was difficult, especially in the area of Mafike Mabatu.
Yes.
It was predominantly white, so we couldn't get much work, and one could not expand. Then I came to Johannesburg and joined a firm of Kunene.
And in between, you managed to sneak in other undertakings. You were once a commissioner in the Small Claims Court.
That's correct.
You were with the Asset Forfeiture Unit as a senior state advocate at the NPA.
Yes, that's correct.
What have you not done? But right now you are a regional magistrate.
That's correct.
Okay.
Justice
that's an interesting. That's a wide scope of experience you have under your belt. You are a member of the South African chapter of International Association of Women Judges. What attracted you to that women's association?
Except I was recruited by two, Judge Collins and Magistrate Chetty. Besides that, I like to advance or give some lectures, assist upcoming magistrates, and more so, I was helping one particular magistrate that also pushed me to that, who was coming in and wanted to be monitored or a mentor, as a mentor on her and others. So I joined the women's judges because the main aim also was to advance and to help in that regard wherever I'm called in that field or in that side.
You've acted as a judge in the Gauteng division
That's correct. Yeah.
since
Just in
2016.
I
How
start-
many, since 2016?
I beg your pardon, Justice?
Since you started acting there in 2016,
2016, January.
and your last acting stint was the 4th term of last year.
Last year, that's correct, Justice.
How many stints, how many terms did you get?
In total, I think I've made 52 weeks. And in most of all of them, except maybe one in 2019, it was the full term. When I'm saying 2019, it was twice. The first term, it was full, half in Mpumalanga, the other half in Johannesburg, and the second term, the other last term, by last 6 weeks or in Mpumalanga.
How many written judgments did you manage to produce during those stints?
So far, Justice, I think it's about plus minus 35 that I've calculated from my side, from the record that I had. There might be more because I could not get all the information due to the fact that at one stage the Justice Department had a problem with the laptops and other things. So we lost some information in that regard.
You do not have any reserve judgments.
I do not have any, Justice Maya.
Well, you're not there any longer. Were you able to get your judgments delivered promptly?
Yes, except perhaps 3 days out for 3 months, I might be out by 3 days or 5 days.
All right. There are quite a number of you vying for a limited number of vacancies. Why should the JSC pick you over the other candidates?
The reason is that I'm appropriately qualified and I've got the skill, I've got the experience, as like Justice Maya said, I've been there, I've done everything, so I've got a vast experience in this regard. So in that regard, and also I believe that I've got the qualities or the characters of being a judge. And I can work under pressure, seriously so, and I believe that, yes, at this stage, if I may just say it, I'm ready and I'm competent. I think that my CV speaks for itself, unless Justice Maya wants me to go more detail in that regard.
No, I have enough for now. Thank you. Colleagues, do you have questions for JP Mlambo? I remember this time. JP Mlambo?
Thank you very much, TCJ. Ra, good afternoon.
Afternoon, JP.
Just some background. Before you came to act in Gauteng, we didn't know each other, did we?
We did not.
You were actually recommended by Justice Molemela. I think she was still JP.
She was JP in Free State.
In the Free State, yeah.
Yes.
That's the one part. But in your attorney days in the Northwest, you worked with the late Justice Monama.
Definitely. He recruited me from the Department of, I was at Land Affairs, as they used to call it,
Yeah.
and he asked me to come and join him, and that's where he opened up my eyes, and I started from State Attorney to Land Affairs and to Justice Manam.
Maybe you can confirm this story because Chief Justice Mogoeng tells it. I'm not saying I'm disbelieving it, but I'm giving you the opportunity that influence of Justice Monama when he was still in the Northwest, he was a strict person. He didn't just give instructions, but he did instruct black practitioners, including Chief Justice Mogoeng.
I was fortunate or unfortunate, but it was fortunate by working with him. He was hard worker. And you will be at the office for I was still young, don't forget that stage. He will be in the office by 5 o'clock in the morning. And then when we leave, me trying to go and family and whatever, I'll leave. Say 5 o'clock is the, what are you going to do? Are you going to watch TV? And there is a lot of work here. Start sitting. So we'll leave at around 9 o'clock. He was very strict. The other thing that I can say about him, why I'm saying he was very strict, he was also meticulous. He is one person when he comes, for argument's sake, I leave a file or the file in the office. It should be, he says, I should not see the next page. So it should be so close together. And if anything that comes out, he doesn't mind calling you.
Yeah. I was looking at the issue of briefing patterns, because briefing patterns is a problem.
Okay.
Yeah.
So he was, I remember Justice Nkaminte
Yeah.
also was still coming up, JP Hendricks, and also Mogoeng, the Justice Mogoeng. So he was briefing black practitioners, and he had this thing. He says, "Collen, what is the difference between you and an advocate? The only thing is that you are not appearing in. By that time, we are not appearing in High Court. But prepare your document so that when you give it to the advocate, he'll be able to advise you properly and also to impart knowledge in that regard." And he was really, really briefing, and the firm came to brief black firms.
But he did not hesitate to stop briefing if you delivered shoddy work. Am I correct?
He will brief you the first time. And then next time he says, "Why did you do that?" Just explain. He was not short of confronting you and asking you, and says, "If you don't improve, I will not give you work." And he was a straight talker.
Okay. Let's come to your acting stints. You've reflected in your spreadsheet that you've acted for 53 weeks in Gauteng.
Okay.
All right. Most of those weeks were spent in the criminal trial court, am I correct?
That's correct, JP.
But you had occasion to do civil allocations as well.
That's correct, JP.
Right. But you also practiced as an attorney, and you did a lot of civil work as a practicing attorney, am I correct?
You are correct, JP.
I see.
And also at asset forfeiture, and you were preparing the papers. You, as an advocate, you will prepare your own motion or affidavit and make sure that when you sign it with the director, and also go and move it in court. Yeah. So I was doing a lot of work also in that regard. It helps me in that motion proceedings.
You've also given us a list of your judgments, which I've looked at, and any particular problems you had in any part of judgment writing in the High Court?
I did not have, I might just say, perhaps bringing this up as I was looking at the comments from LSSA,
Yeah.
wherein they were concerned about my grammatical errors and spell check. It's regrettable in that judgment. I know that we heard the matter. I was with Judge Bakwa, and we heard the matter today, and the following morning, I had to produce the judgment. I think it was 17, 18. So I think I did not give it much attention in that. And as I say, I really regret that errors, and I undertake and I take it that I will not repeat. But I may just add further that because of the kind of skill of profession that I had as a notary and as a conveyancer, one has to be very, very meticulous and very careful of what you do, because it can have an impact on your clients. For argument's sake, or as an example, if you are doing a transfer for a client and you spelled his name wrong, it will come back that he has to correct. So one has to be very careful. And also when it comes to notarial work, it's been used overseas.
So
You have to be meticulous. So that's what I'm saying.
It's a regrettable error.
Yeah, and further that I did not have much problem. I was fortunate whenever I had two mentors in Pretoria when I was doing my sting there. Judge Mamuruti van der Schijf, Judge van der Schijf, I call him Mamuruti, and Judge van der Westhuizen. They were guiding me. They were definitely giving me and Judge Divorce. I was fortunate to have them in my corner.
Yeah. Well, in your list of judgment, you've listed 41 judgments, but what's notable is you've listed about 25 criminal judgments, 26, and 16 civil judgments. But I think the civil judgments could be more. But you mentioned that the justice IT system crashed and a lot of information was lost. Do you ascribe that to that?
That's correct.
Okay. No. Thank you very much. And you regard your time in practice, your acting stints, and the fact that you are a judicial officer, you are a magistrate of many years standing. That stands you in good stead to say you are ready to take the
permanent post.
The permanent position.
That's correct, JP.
Thank you. Thank you, DCJ. No further questions. And DCJ, MEC Mamabolo has just joined us. He's sitting against me. I don't know why.
Thank you, Deputy Chief Justice. Good afternoon.
Good afternoon, Commissioner.
I just have to declare that you are one of the people who encouraged me to do notary.
That's correct.
Even very late, because you always said, why don't you are a conveyancer, why don't you complete the whole course and do notary? And I did it very late, but it was very, very, I really appreciate that. I do know that you were a convener of a notarial exam for the Law Society of the Northern Provinces then.
That's correct.
So, and you did some lectures, lecturing attorneys on notary. So do you think the standard of notary and conveyancing, because you know why? I'm worried about the failure rate, and they always blame the LPC that we are failing them. Do you think maybe we need to do something about it? Because I know you're very passionate about it.
If I look at the beginning, when I became a convener and examiner, I believe it was very strict and the candidates or the student pupils, I'll call them pupils with due respect, and the candidates who appeared there, they were well prepared. Nowadays, attorneys with due respect also, they are after money. They are interested in making money without looking at the quality of work. So whenever a candidate comes to us, especially for the orals, because in the olden days, most of us will understand that even if you had passed by 50% or how many percent, you still go for orals, because the law was saying you must do the practicals and also no understanding of practicals and theory. Currently, yes, a lot has to be done. The passing rate, if the old, when I'm saying the old teachers or the old conveners and examiners, we are very strict, or we are strict, and we need very strong people who understand the law. And LPC can do a lot by doing the trainings. I don't know whether it still continue, but if they do, it has to be rope in experience, the past notaries and past conveyancers to come and do the lecturing and help in that, and emphasize to the students or that the main is to produce the best and the good quality work, not run after money. So LPC can help a lot in encouraging the students, the attorneys. The passing rate, yes, went down a little bit, it used to be, it was, the last time I was checking, like 21% of all the candidates. And it seems, I don't know whether they are no longer interested, but the passing rate was very poor.
Okay, thank you.
Thank you. Thank you, Commissioner.
Commissioner Nokes?
Justice, in circumstances where sitting as a judge, just after you have delivered your judgment, you notice that, well, there is an omission in your order.
There is
you intended to say to grant cost of 2 counsel, but you omit to say including cost of 2 counsel. Judgment is
the cost in the cost.
No. What I'm saying, you intended to grant cost of 2 counsel.
Okay, yes.
But when writing the actual order, you omit to say cost of 2 counsel. You issue the judgment. You just discover this later. What are your options?
Discovered later when...
After the judgment has been given to the parties.
If you were ready, if in most cases I prefer to read the judgment, especially the order, onto record. So what one will have to do in that regard to make sure, one, is that if it's still there and you have pronounced it on record, you'll be able to find it. But you can still correct the error because of saying, for argument's sake, you said cost, and you wanted to say cost of including for 2 counsel. So in that regard, you can still rectify the mistake as long as you are not going to change you are not changing the whole judgment as whole.
No, I'm not sure whether you follow me. I'm saying we have issued the order, the judgment is already given to the parties. You discovered in the morning, hey, when you look on this judgment, I did not include cost of 2 counsel. What are your options? Do you have any options?
The option is to call the parties and rectify the mistake, because you wanted to do that in that regard. Otherwise, the only option which will sometimes be left now is to take it on review or take it up on appeal, but it's costly because it's just a mere mistake in that regard.
Who must take up it on review or on appeal? Is it you as a judge? You say, you will advise the parties to review your judgment or appeal?
On appeal, or just take it on appeal for the cost sake. But in most cases, you can still rectify it in that regard.
my last question, which is the second one. Now, in a trial where there is an expert to give an evidence, an expert gives an evidence. Now, when you are judging, when you are approaching that expert evidence, what are the guidelines? How should you approach an expert evidence in your judgment?
Remember that an expert, as much as he's called by the parties to come and testify, he is there to give guidance to the to assist the court in that regard. So you must make sure that he knows or he fulfills the requirements of being really an expert, and during his testimony or the time that he was called, you have clarified and you know that he is knowledgeable about in that field that is coming to give you an opinion about it.
Otherwise, your point is that my point is are you bound by that evidence? What an extent is that evidence?
You are not bound. He's there to assist the court, but the last word, or if you feel that you cannot go with it, that you are not bound with his opinion in that regard.
President Betty? Oh, sorry, Commissioner Nyambi came before you. Commissioner Nyambi, sorry.
Thank you, DCJ. Morning. Afternoon.
Good afternoon, Commissioner.
It's been a hectic day. Having acted in the Gauteng division, what were your observations regarding challenges that you think elevation to the bench will assist to deal with?
There is one thing, so far, I will say, I'm not buying the JP's face. He's doing everything that is best, that is good. He has an open door policy. If you've got an issue, you've got a problem, you'll be able to go to his office. Even if you are at home or whatever, you call him at night or anytime, he'll be able to assist you. So, challenges that are there mostly, I will say, we've got shortage of researchers, because if you do judgment and you want to pass it over, that it has to be looked at by the researchers. If you can be empowered or given more work extra staff. The other challenge is that in most cases, when acting judges come and act, you bring your own laptop, you bring your own apparatus, I'll call it that way. And then you do your own judgment, you type your own judgment. So it will somehow help by getting, even if it's a desktop in that office, so that you'll be able to. And certain offices are, it's just a desk and a table. It's a table and a chair. They don't have library, and you have to. I know nowadays you can Google and find, not Google, but look into the system. So into the computer and look for research and do that. But it will help if something is there that can assist, especially acting judges in that regard.
If you can share with us your understanding of the connection between the rule of law and democracy.
Okay. South Africa, it's one sovereign democratic state where it's founded, among other values, being the supremacy of the Constitution and the rule of law. The Constitution is the supreme law, and any law or act which is inconsistent with it is invalid, and one has to comply with all the obligations of the Constitution. The the law is equal. Everyone is equal before the law. Let me say, everyone is equal before the law. The legislature and the executive receive their powers from the law, and it is the duty of the judiciary to look after, as the guardian to the constitution, to make sure that the legislature and the executive apply the law accordingly. So the rule of law, it's one of the cornerstones of our constitution and also of our Bill of Rights.
Is there a connection between the rule of law and democracy?
There is a connection because you have to be sure. I mean, if one is not doing the law or correctly applying the law, the democracy won't be any democracy in that regard. It look like a sovereign state wherein we only believe in one state. So yes, there is a connection between the two.
Thank you. Thank you, DCJ.
Thank you, Commissioner Nyambi. President Petty.
Thank you, DCJ. Good afternoon.
Good
Mr.
afternoon.
Matshitse.
Good afternoon, Acting President.
Mine is more of a comment than a question. And I'm happy that as a conveyancer, you were acutely aware that an error in a deed could be costly for a client. And the same applies to a judgment, especially the order. Because if the order is ambiguous or contains a patent error, a litigant would then need to invoke Rule 42 and go back to court for the correction of the error. So all I want to say to you, if you are recommended for appointment, you must always keep that at the forefront of your mind.
I really appreciate the Acting President for enlightening me, for reminding me that. Thank you very, very much. I'll keep it in the back of my mind all the time.
Thank you, Mr. Matshitse.
Thank you.
Thank you, DCJ.
Commissioner Ramachai.
Thank you very much, DCJ. Good afternoon, Mr. Matshitse.
Dumela. Good afternoon, sir.
No, ke a leboga. I just want to find out, as a magistrate, right? Currently, in the people who are accused or who are suspected of having had committed crimes, and they are arrested overnight, maybe on Friday, there are provisions in the Criminal Procedure Act for them to be able to either apply for a police bail or a prosecutor bail, right? And in practice, it seems like that process is not working for honest attorneys and practitioners. In other words, you will be called at 10 o'clock because you don't have the connections and dynamics of the area. You will be taken from pillar to post, and your client might not be released, and you will have to go to court on Monday to do that. How best can this issue of out-of-court bail be used to benefit those people who are suspected and arrested of crimes at that level? I'm not sure if you are aware of the challenges that I'm talking about.
If I may answer that by saying, Joburg magistrate, they've got prosecutors who are standby. It can be put in that fashion, or in the sense that prosecutors are there the whole night. They're supposed to be available. Even if he wants to go for a gig or anything, if you know that you are on rotation, it's like, I will say in the High Court, when you are on agent, you should make sure that you are available. So if it's kept strict and observed that who was on the roll, who was doing the work on that weekend, that he must make himself available. That's in regard to bail at the, for the prosecutor. And also, the prosecutor must have, if possible, I know that magistrates mostly do not act during the night, but if the system can also introduce to help that we or the magistrate also, somehow it's your turn this weekend to work, so that whenever they call you in that, so that when an accused or an attorney is able to the police are running around, he can take the matter straight to the magistrate, failing which I know that it's costly, but he has the High Court to bring an urgent application. I know it's a lot in that regard, but in order to assist as much as what we are saying, I have been there as an attorney also, that you find that worst part of it is that the police will move the accused from one town or from one police station to another. When you get there, he's nowhere to be found. When you ask the commander, he also switches off his phone. But if you've got a dedicated, there is a, let's say, cell phone that is known, that is given that in this area, if you want help, this is the person that you phone, or you phone that number, then in that regard, it will be able to get, you will be able to get some help.
No, thank you very much. My last question is in relation to, not generally, there are instances where most of the cases that, or some of the cases that are coming up on review from the magistrate court to the High Court, where judges show their displeasure at the level of responsiveness from the magistrate, right? And with the quality of the queries, the way they are actually responded to, and the time within which those responses are actually provided to the judges for them to be able to successfully look into this, and the preparation of the record and all those things. I'm not sure, in your experience at the regional court, and of course with your discussions with your colleagues, have you experienced this? What really is the root cause of this? Because it goes into the fundamental rights of the accused, some of which might be, at the time when this review is going, they might be behind bars.
Sometimes I will say, I don't know, some magistrates are afraid. When they get a letter or some query from the judge, instead of answering, he will duck and dive without responding to the set issue, what is being called. Yes, it's a problem. It has to be addressed. In most cases, I will say, perhaps if it can be taken with the commission, the magistrate commission, that it must be one of the rules, and it's there. It's one of the code of conduct that you have to respond very fast, or in that regard. Maybe for those who were attorneys, we know that by not responding to the letter of your colleague, it's regarded as you can be disciplined for that, for failing to respond. The same with magistrate. I know they are independent, we are independent, but you have the duty, because you are affecting the rights of other people. Perhaps even to make it worse, you find that you are delaying and the poor person is lingering in custody. If you had the respondent in time, that regard, you will have, he should have been released. But what can be done, it's one problem, but perhaps engage the JP or the Chief Justice, the office, because they've got the meeting always that they meet, and emphasize, and if need be, he can request the Chief Magistrate or the Regional Magistrate to provide him with the list of, if you've got the list from the judges, say, since I wrote this letter, I know that we, as a review, you put it, the file, you put it, and then it goes to the registrar's office. Sometimes they don't even follow it up. But if it's, the JP knows, and he's being given the list, and even worse, the name of who is responsible. It's Collen, Matshitse, why are you not responding? Can you give us a written explanation why it's not been done. So in that regard, it can be assist a lot in that.
Yeah, Leboga. Thank you very much,
Thank
Deputy
you.
Chief Justice.
Commissioner Makonish?
No, thank you very much, Deputy Chief Justice. Good afternoon, sir.
Good afternoon, Commissioner.
No, I only have one question. I think you are the best person to answer this question because you have practiced as an attorney, you have been a magistrate, and you have been part of the public service. Do you think that state advocates and prosecutors should be allowed to be acting judges? And if yes, why? If not, why not?
I won't say that it's a simple one, but depending whether they will be able to be impartial and be able to be free. Because in most cases, in the olden days, I would say in the olden days, in the sense that the prosecutors were a little bit independent. They will be able to can take a decision without. Nowadays, they say there is seculars, and a prosecutor who appears before you, he can't even take a simple decision when he's appearing before you, whether to withdraw a case or whether to say he's proceeding with the case. He will say, I'm taking it to my SPP. And SPP will delay most of the time. So I know it's not easy to say that, can they come and act in that regard as prosecutors? I mean, as acting judges. I will say, like the magistrates or prosecutors are also appointed as magistrate. For prosecutors, they should also follow the same line, be called on to act as magistrate in the district and get to know before they get to be acting in the High Court. With regard to the advocates, also they can be allowed or given a chance to advance, but it will be in a, I would say, up to a person. Is he able to can balance, saying that when you are on the bench, you are not for the state, you are not for the litigant or the accused, let's put it that way. You are there for justice. You are there to obey, to follow the Constitution. What does it say? And in that regard, I will say, yes, and also be given a training in that regard. Thank you.
Thank you, TCJ. Thank you, sir.
Thank you, Commissioner Makonish. Are there questions from the virtual platform?
Yes, Deputy Chief Justice. If
Go
I may.
ahead, Commissioner Singh.
Thank you very much, Deputy Chief Justice. And good afternoon, Mr. Matshitse.
Good afternoon, Commissioner Singh.
Thank you. Just one question. You know, we speak of the fourth industrial revolution, and it's become a revolution which all the young people just take like duck to taking to water. I would just like to understand your technical competencies in being able to manage this 4IR, because you would realize that even during the period of COVID, the system didn't shut down. There were still matters being heard on a virtual system. So if you can just speak to your technical competency in that regard, and whether you think it's something that's here to stay.
It's here to stay, if I may put it there. Not talking for my alma mater, UJ, the professor there is pushing it, and it's something that you cannot run away of. And I would say it's a good thing, and it's something that has to happen. I'll give an example. When people are growing up in the rural areas, if at the tribal office, everybody, let me just start by saying, everyone has a cell phone. It's easier for a person to can log in and wherever he is, be able to can conduct the proceedings, be able to stay. Yes, we have a problem of load shedding. And if we are in one area, it will be easier for people to can go and join at the tribal authority or a tribal office. And with solar system, which is being introduced, it won't be that much of a problem. But I will say it is here to stay. and it's going to be applicable at all the time, and it will cut costs of people moving, like witnesses' fees and things like that. I don't know whether I've answered you, Commissioner.
Yeah, and just as a follow-up, how have you beefed up your technical competency over the years to deal with computers and etc.?
I used to work with Mr. Judge Rachivumo, and he also encouraged me in that regard of when it comes to computers and all that. I won't say I'm a computer guru, but I do understand it, and I do help my colleagues when it comes to computers and setting up and all that. I have a bit of a knowledge. I like to challenge, or I like a challenge and go and look at that. I'm one person who, besides reading, also like technology. I love technology. For me, cell phones or whatever that is got technology, I would like to join and see how far it goes.
Yeah, that's very good to know. That's very good to know. We're all trying in that area. You presided over cases where gender-based violence and violence against women and children, and one of them is the baby Daniel murder case.
Yes.
Do you think that there is a further role for the judiciary to intervene with and having due regard to the separation of powers, so that you can make, as a judiciary, a meaningful contribution to reduce the scourge of gender-based violence, particularly against women and children?
One will say it's growing. I'm saying it's growing, and there is, when it comes to children and women, and what I can say is that the judiciary is there as a guardian, as I said, guardian of the Constitution. So it's got a big role to play. That one cannot go away. So when it comes to GBV, the act has also, or there's been an improvement. The latest act which came in, even the domestic violence, which started, the certain sections started with August in this regard. So it is there, and it can be done. The judiciary can also help by, whenever they do judgments and things like that, that they bring it up more and more. And people are taught and given a chance to say what is right and what's supposed to happen in that regard. I don't know whether I've answered.
No, well, I'll accept that answer. Thank you very much, Deputy Chief Justice. Thank you.
Thank you, Commissioner.
Thank you, Commissioner Singh. JP Wegley.
Good afternoon, Mr. Ashile.
Good afternoon, Commissioner.
Sorry, I didn't get. Oh, thanks. I'm a bit deaf. Sorry, thank you. Good afternoon. You are one of the few people who has been admitted as a notary public.
I beg your pardon, sir?
You're one of the few that I know who was admitted as a notary public. It is one of the most frightening things for every attorney to go and sit to a notary public examination. It's a very specialized field.
That's
and you didn't only do it and become a notary public, you also lectured in it, or trained in it, set exam papers. So you were one of those people who frightened all candidate attorneys and attorneys. But I want to know is, since you've been a magistrate, which is from 2015, have you kept in touch with the developments in the notary field? And I ask this because you might be just one of very, very, very few people, judges, who actually admit as a notary public if you are recommended and appointed as a judge. So my question is, have you kept abreast with the developments?
I like to read. I do like to do a research. You have to, once a notary will always be a notary because you are called upon at any stage to can give an advice, not give an advice, deal with a matter that deals with this kind. I'll give just a small example. There is a recent judgment by Judge van der Schijf, wherein the question, it involves, I know, matrimonial property, especially wherein it's a marriage out of community. And it involves, I will say, a notary because it's out. It's a marriage out of community. But can the person benefit with regard to pensions and others? So one has to keep on abreast with development in this regard and all the laws that is applicable. Yes, I have been keeping contact.
Thank you, because I remember about 25 years ago, I was rushing to court an urgent matter, and I had to speak to the judge, and I told him, I'm coming to perfect a notarial bond. And he asked me, perfect? What do you want me to do? You know, I'm sure whoever phones you will not have that problem. And I'm also sure when your JP gives you a matter to deal with the confusion in an ANC, you will know it's got nothing to do with the African National Congress.
Thank you.
Thank you.
And commercial matters. Thank you.
Can I follow up, DCJ?
Sorry?
Can I follow up on?
Yes.
Yes. I'm sorry, Matshitse, I just want to understand, perhaps maybe I did not understand quite well. Are you saying that if somebody is married out of community of property and out of community of profit and losses, that person will be able to share in the pension benefits should they divorce?
Okay.
Is that your proposition?
No, I was saying it's a judgment that is being done by my colleague, Judge van der Schijf, which he declared one of the sections that are on the Matrimonial Act that, because the rule is one, or when you are married out, I always call it out. We don't share anything except the blankets. In that regard, when it comes to your benefits, pensions and things like that, you don't benefit. But what about the person who has been home taking care?
Oh, I understand. No, thank you very much, Deputy Chief.
You don't appear to like the answer, Commissioner.
I think the last part, I kind of agree with it. I was concerned with the first part.
Okay. Well, we've reached the end of your interview, Mr. Matshitse. Thank you very much. You're free to go.
Thank you very much, Justice Maya. Thank you for the time and everybody. Thanks to the Commissioner.